Thank you very much. It's my pleasure to be with you today, and I sincerely appreciate the offer for IEEE input throughout our rulemaking process so that you all can join us in figuring out what are the best rules so that we might have a solid 21st century patent office. So what I'd like to cover with you today is more about the process that we are going to follow in implementing the various provisions of the Act. We have a number of challenges. Oh, well, I guess my slide set kind of skipped over. We have a number of challenges that the office is facing. I know those of you who've had a chance to read the legislation to date recognize it's close to 110 pages, 37 different sections. Now, obviously not all of those sections implicate the Patent Office. Many implicate litigation matters, but there's a huge number that implicate the Patent Office. So it's our job and our goal to implement them in a complementary fashion so that nothing turns out at being at odds with each other. We don't want to set up a structure for supplemental exam that conflicts with the structure that we set up for the contested case proceedings. We also must do these implementation activities in very short order. We've grouped the provisions within the Act into different buckets based upon their effective dates. And we shake down with 3 buckets. Those provisions that go into effect within the first 60 days from enactment, those that go into effect 12 months from the date of enactment, and finally those that go into effect 18 months. And on my slide, you'll see that I refer to these provisions as Group 1, Group 2, and Group 3 respectively. Now, in addition to our rulemakings, we have various studies that we are required to conduct either as lead counsel, lead agency counsel, or in collaboration as a consultant to other governmental entities. And then overlaid on that, we have many internal issues that we will need to address in our implementation. Our automation systems, as you've probably all heard, are fairly dated. Most of the provisions will require updates to our IT infrastructure. We're going to be in charge with hiring personnel. We face a current backlog. We're also adding many new proceedings that we're going to have to manage that are not on our record books today. So our goal is to hire 1,000 new patent examiners by the end of the next fiscal year. And the end of this calendar year, we plan to hire 100 patent examiners. We also plan to hire 1,000 patent examiners, 100 by the end of the year. We also plan to hire 100 board judges, 40 by the end of this calendar year. And then I think together, we have to manage all of these various provisions that need to go into effect in short order, coupled with our operational difficulties. So it will be a challenge for the agency, but we're not facing this challenge alone. As many of the prior speakers have indicated, we want the public to be very much involved in this process so that we can do this in a collaborative fashion. We'll receive the input from you, take that input into consideration as we structure both our proposed rules and our final rules. So on the slide in front of you today, I've listed the provisions that are in Group 1. All of these provisions have gone into effect except for the very last column, the electronic filing incentive, which will go into effect on November 15th. Now, I'm not going to read the names of all of these provisions because what I've done is I've presented follow-on slides where I will walk you through each provision, when it went into effect, and then how the agency implemented that provision. So for the IP re-exam threshold, this was talked about earlier this morning, so I won't spend too much time on it. But what the provision does, it requires an elevation of the standard to initiate an inter-parties re-examination. The standard will increase from substantial new question of patentability to a reasonable likelihood that at least one of the challenged claims will be found to be unpatentable. The standard for ex parte re-examination remains at a substantial new question. Now, the second thing that's going to happen in a year from now, inter-parties re-examination will terminate. It will be replaced by inter-parties review, what we're calling IP re-examination on steroids. So that means requests that are pending before September 16th, 2012 will be considered by the office. A request that's filed on or after that date for inter-parties reexamination will not be entertained. The office will deny the request, and the applicant, if they want to pursue, the third party at that point, if they want to pursue a reexamination or a review, will need to resubmit a request for inter-parties review. And the entity at the agency who will consider inter-parties reexamination versus inter-parties review switches from the CRU to the newly formed previous BPAI, our newly formed PTAB. Now, here's a chart for you so that we can keep straight what the standards are before September 16th, between September 16th of 2011 and 2012, and after September 16th, 2012. And to date, in this interim year period, when we're under an elevation of the standard from SNQ to reasonable likelihood, all the other rules that affect inter-parties reexamination are the same. The only difference is a change in standard. So on this slide, I give you the Federal Register notice where we've made the rule change, along with the listing of the 4 rules that have been changed. The next provision that went into effect on the date of enactment is tax strategies being deemed part of the prior art. This provision requires that any method or any strategy for avoiding, reducing, or deferring tax liability will not be sufficient to render your claim patentable over the art. That portion of your claim will be treated as part of the prior art. Now, there's 2 exceptions here. One is an exception for some sort of method, apparatus, or technology for preparing a tax return, something along the lines of TurboTax. And then the second exception is method, apparatus, technology for financial management system. We have implemented this provision through a memo to our examiners. There's only a very small subset of examiners who will be impacted by claims directed to this subject matter. So we've accomplished it through a memo. The memo contains an example from a computer-related technology, and there's also been a new form paragraph created that the examiners will apply in making this type of rejection. You also should note it applies to any application filed on or after the effective date, as well as any reexamination or what I'm going to call a post-issuance proceeding, one of the contested cases that are initiated after those provisions come into being. The next provision is best mode. It went into effect on the date of enactment. And for the Patent Office, essentially it's business as usual. Best mode does not change as far as being a condition for patentability. It remains in Section 112, Paragraph 1. Best mode is no longer available as a defense in an infringement proceeding. The other place where best mode does not remain is in a post-grant review proceeding. It cannot be the basis to trigger a post-grant review once that proceeding becomes available. Now, our form paragraphs, our MPEP sections, all of those are in place. But I will say that the reality for the Patent Office is we do not make too many best mode rejections. Normally, unless there's some mechanism by which the examiner would become aware of best mode, perhaps through some sort of declaration or otherwise, the examiner won't know if the inventor subjectively contemplated for a best mode. So it is a rarely used rejection, but it does remain on our books. And we thought the memo to examiners was important to train them that, you still have to examine for best mode to the extent you're aware of it, and they aren't confused by the applicant pool saying, oh, best mode no longer exists in the law. The next provision is the human organism prohibition. For us, again, this really is business as usual. In the 1980s, the Patent Office issued an OG notice indicating that we would not issue claims directed to a human mammal. Now the America Invents Act has caught up with our official Gazette guidance, and that's essentially what the provision of the Act prohibits, patenting of a human organism. We implemented this through a memo to our examiners. Again, there's very few examiners affected by this change, and so they're already very familiar with the practice. So there was no need to issue any type of rulemaking or further guidance. Venue change. So suits that are going to be brought against the agency, starting on the date of enactment, the venue will change from the United States District Court for the District of Columbia to the Eastern District of Virginia. And on the slide, I list for you the relevant proceedings. We have practitioner disciplinary proceedings where the office is bringing a case of misconduct, alleged misconduct against a practitioner. That won't implicate any of you, of course. The next one is a board decision coming out that you want to challenge. Instead of going directly to the federal circuit, you can take a 145 action into a district court. The next one is an appeal of an adverse interference decision, a patent term adjustment decision that an applicant disagrees with. And then the last one's not used too often, but it provides for venue for a non-U.S. resident in the Eastern District of Virginia. Now, the OED statute of limitations, starting on the date of enactment, has been expanded. Prior to the America Invents Act, the PTO operated under the Administrative Procedures Act 5-year statute of limitations for bringing a case of misconduct against a practitioner. And it was 5 years from the date of the alleged misconduct. The America Invents Act gives us a 2-tier system. The PTO must bring a case of misconduct against a practitioner as to the earlier of either 10 years from the date of the alleged misconduct or 1 year from the date the alleged misconduct is made known. And here's the language of the America Invents Act: an officer or employee of the office. Now, we are planning to issue a final rule to identify who can be a qualifying individual to learn on the PTO side of the misconduct. It's probably someone other than Director Capos, and it's probably other than a docketing clerk. Can an examiner qualify? That's what our rulemaking will sort out. More than likely, it's going to be someone within the Office of Enrollment and Discipline. But it's come to our attention that this provision might not be clear to the public as to who should qualify, so we want to go out with a final rule to give further definition to this statutory provision. Fee-setting authority. On the date of enactment, the Patent Office acquired the authority to set fees for all patent and trademark services, or adjust fees if we already have fees on the books. But the Patent Office did not do so on the date of enactment. We are going to engage in notice and comment rulemaking to exercise our fee-setting authority. So it'll be some months down the line. Our goal is to accomplish this fee setting within 12 months. The process, however, is a bit complicated, more complicated than the average Administrative Procedures Act rulemaking. Under the terms of the America Invents Act, we must engage our Patent Public Advisory Committee. The PPAC will hold public hearings to talk about what our fee-setting structure is, to collect your feedback on that fee-setting structure. The PPAC also will prepare a report for the office regarding our proposed fee structure. Overlaid on the PPAC process, the office wants to engage with OMB and the Department of Commerce to tap into their oversight of our fee-setting authority so that we get their input. The process is very complicated for us. I have a science background. I'm not a financial person, but it's going to delve into issues like our cost basis, our operating reserve. There's a complication because part of our budget is tied to the president's budget. The president doesn't normally release their budget, and it's required the second week of February every year. So that puts a constraint on how quickly we can move in the process and reveal our budgetary numbers, because we can't do so before the president reveals those for the federal government at large. Also within the process, Congress has an opportunity to adjust our fees or correct any that they believe are not in line with or reasonable standards. 45 days before a final rule comes out on fees, we must give Congress notice of our fee structure and an opportunity to adjust it. So because the process is complicated and involves many different agencies, we might not be able to accomplish it within our 12-month goal. It's probably going to exceed 12 months, somewhere on the order of 16 to 18 months. Now, the structure of our fee setting is going to be different than the way we set fees today. Under our current fee setting authority in Section 41 of Title 35, we set fees to recover the cost of the service. So if it costs us $500 to execute the service, that's the fee for the service. Under the America Invents Act, our fees, we won't follow that cost recovery model. We're going to follow what I call an aggregate model, meaning the aggregate cost to run the agency, including our operating cost, must equal our aggregate revenue. As long as that exists, so that we're never in the red, the cost that we set an individual fee can be subjective to the Patent Office's discretion under our fee setting authority. So we could incentivize certain behavior and disincentivize other behavior by the cost for the service that we set. As long as the total cost equals the total revenue, then we're in compliance with the terms of the Act. So you can see that adds another complication onto the process as to exactly what fees we should incentivize, what fees we should disincentivize. We've already had an economic conference with economists from around the globe to start giving us advice on the scope of our fee structure. One other thing I want to point out is that small entities and micro entities will qualify for discounts, 50% and 75% respectively, for, and this is the language of the statute, fees related to filing, searching, examining, issuing, appealing, and maintaining patents and patent applications. So one thing you might want to consider here is where do the contested case proceedings fit into this statutory language? Are they related to maintaining a patent? Because it's a third party seeking to take down a patent. So if a small or a micro entity seeks to avail one of these contested case proceedings, will they qualify for a discount under the terms of the statute? I think that's one of the issues we're wrestling with right now. Now, a micro entity is a newly created entity under the terms of the America Invents Act. It's defined by the statute. It's four-part definition. First, the entity must be a small entity. Second, there's a restriction on the number of patents that the entity could have previously filed for.
A named individual, or is it a small corporation? In the first dot, you talk about a small entity, which would include a corporation. The second one, you speak of an inventor.
The language of the definition speaks in terms actually of the applicant. So we look at the applicant to identify whether the definition is met. We recognize there's some ambiguities here. So it's our plan to come out with notice and comment rulemaking on the scope of the micro entity definition when we come out with our fee setting authority rulemaking package. Because there's some confusion, and I've gotten a lot of questions as I've gone out and talked about this definition. The third requirement is there's a restriction on income. The applicant cannot have a gross income exceeding 3 times the median household income, which is around $150,000. And then lastly, the applicant cannot be under obligation to assign, license, or convey their patent to what I would probably call loosely a large size entity. If the micro entity meets this definition, or the entity meets this definition, they're entitled to the 75% discount on fees. Now, here's a couple questions I've added to the slides because of talking to the public. Applicants are not considered to be named on the 4 previously filed applications if by the terms of their employment contract, they were under an obligation to assign their invention over to their previous employer. And then lastly, applicants employed by universities may qualify for the micro-entity discount. Because the micro-entity discount is tied to our fee-setting authority, under the terms of the Act, I want to be clear, the micro-entity 75% discount is not available today, won't be available tomorrow. It is not going to be available until we exercise our fee-setting authority, so some 12, 16, 18 months from now. In the meantime, a micro-entity qualifies for the 50% small entity discount. Prioritized examination. In terms of our examining world, this is probably the biggest provision that you all will want to know about. It went in effect on September 26th, and it allows for, in short, fast-track examination of an application that's a utility or plant that meets certain requirements. First, the application cannot contain more than 4 independent claims, 30 total claims, and no multiple dependent claims. The application also must be filed electronically, and that applies only to the utility application. A plant patent application cannot be filed electronically. And the applicant must pay a $4,800 fee, reduced by 50% for small entities. The prioritized exam does not apply to international applications, provisional, reissue, and design. It also doesn't apply in a reexamination proceeding. It will apply to continuation, to child applications, continuations, divisionals, CIPs, but the applicant must make a new request in the child application. The request from the parent will not carry over, and all of the conditions that have to be met, including the fee, apply to the child application. The office has a goal of disposing of a prioritized examination within 12 months on average. And what do I mean by a disposal? Well, a final rejection, a notice of allowance. There's a few others listed in the rule package, which I'll give to you in a moment. And then an applicant can self-select out of prioritized exam by doing one of two things. First, the applicant can amend the claims to exceed the limits, the 4 independent, 30 total, no multiple dependent. Or the applicant can file a motion for an extension of time to respond to an office action. Either way, the application will be taken off the examiner's fast-track docket, moved on to their regular docket, and there will be no refund in the prioritized examination fee. Now, in a given fiscal year, the office may not accept more than 10,000 prioritized examinations. So far this year, last fiscal year, we received 842. And I don't have the stats yet on how many's been granted, how many's dismissed, and the breakdown of tech centers, the breakdown of the identity of not the identity, but the classification of the inventor, large inventor, small inventor. As of last Friday, we had 92. I don't have the slides updated. How we're tracking this, and so you all will know, is on our microsite. We have a table that I update every Friday telling you what the latest stats are, so you know where we are in the 10,000 count. I think it was, don't quote me on this, I think when I posted yesterday, it was around 200 and some as of this Friday. Okay. So one interesting thing on prioritized exam, the fee that y'all pay for prioritized examination is money that directly goes into the PTO appropriations account. That means that the PTO immediately has access to all fees it collects from prioritized examinations. We implemented prioritized examination in a couple of rule changes, and I list on this slide the Federal Register notice for you. The 15% surcharge on all fees also went into effect on September 26th. Now, this is like a stopgap measure. The 15% surcharge is going to exist from September 26th until we exercise our fee-setting authority. So it will go away in due course. It does not apply, there's 3 exceptions, international applications, certain petition fees, and the enrollment fee to become a registered practitioner is not subject to the 15% surcharge. I think I give you on the slide the fee table. The fees listed on this table include the 15% surcharge. You don't have to tack 15% onto the fees. And we notified the public of this change through this Federal Register notice. It doesn't contain rules per se. It's just a notice providing the fee tables. Now, the reserve fund went into effect on October 1st, and this created what I like to think of as a savings account for the PTO. It's a separate fund from our appropriations account where all money collected in excess of the amount appropriated to us by the Appropriations Committee is housed. In order to access those funds, the the Appropriations Committee must give us the authority to tap into the account. So far, we've gotten positive indications for fiscal year 2012 that the appropriators will give us access to all of the funds in our savings account. Now, the reserve fund also does something else. It creates a fence between the patent and the trademark funds. Patent funds cannot be diverted over into the trademark side of the house, and then vice versa. Before the American Invents Act, there existed a fence on the trademark side, but there wasn't a fence on the patent side. So now there's a fence on either way.
Is there other functions like the Trilateral Commission, things like that? Do each of those buckets of money pay into the Trilateral Commission for tracking EPO and JPO? Who pays for that?
That's a good question. I don't know who pays for that. I can't tell you the details of that. Yeah. The electronic filing incentive is the only provision that's not gone into effect yet out of the Group 1 category. It will go into effect very soon, November 15th. It attaches a $400 fee onto all applications that are filed in paper form. It's reduced by 50% for small entities. So this is to encourage electronic filing of all papers made before the office. An interesting little fact here is the money that we collect from the prioritized examination, from the electronic filing incentive, that money goes into the general treasury account. The PTO never collects that fee. We don't see it in our appropriations account. The Department of Treasury uses it as it sees fit. We implemented this provision in this rule package, and I also list for you the few applications to which the electronic filing incentive does not apply because you can't file these types of applications electronically. Now, Group 2 rulemakings, these are the provisions that go into effect 12 months from the date of enactment on September 16th, 2012. I am not going to talk about each of these provisions in detail. You got a very good overview on many of them this morning from the co-presenters at this conference. What I want to cover is that the Patent Office is spending our resources right now developing our proposed rules for these provisions. And to that end, I want to walk through. We're going to have 10 proposed rule packages come out very shortly, mid to late January, and so that we're clear on the scope of what those packages are going to cover. Inventor's oath and declaration will be in a rule package. Third-party submission of prior art for a patent application, its own rule package. Supplemental exam, its own rule package. Citation of prior art in a patent file, its own rule package. So there's 4. Priority examination for important technologies. At this point in time, the office is not planning on making a rule package to create a specialized system of prioritized exam for technologies that the director determines to be important. Maybe an example is green tech. This is to be distinguished from the priority examination I talked about earlier. That provision is in effect, it's available for all applications across the board. This provision would be for specialized technologies that we define as being important. So we're not making a rule package for that that's going to come out in 12 months. And then we have the 3 contested case proceedings: inter-parties review, post-grant review, and the transitional program for business methods. Each will have its own rule package, but I want to put a little asterisk here and come back to it when I get to the next slide. On this one, I list for you the provisions that go into effect in 18 months, March 16th of 2013. There are 3 of them. Now here's where the asterisk comes in. For derivation proceedings, we are running that rulemaking on the same schedule as the contested case rulemakings. So now let me explain how many we're going to have there. So we have 4 from the top provisions, and then you see there 3. Derivation makes 8. Now how do I get to 10? Well, we're doing something special for the contested cases. We plan on having an umbrella set of rules that are akin, my best analogy would be like the rules of civil procedure, that govern procedure in the sense of what types of papers can be filed with the office in a proceeding, the number of pages, the font size, where to make the filings. These umbrella rules will cover the 4 contested case proceedings. So they then the nuances of the contested case proceedings will go into the specific package for that proceeding. Like post-grants of reviews only available within the first 9 months. Inter partes review picks up from 10 months through the life of the patent. Those details go into the nuanced packages. And then how do we get to 10? Well, the last one is going to come up with the transitional program for covered business methods. There, we are required to have a definition for a technological invention. If an application is drawn to or patent is drawn to a technological invention, then it will not qualify for this transitional post-grant review. So we have to know the meaning of that term. And so we're going to define it in a separate rule package, which makes up our 10th rule package. On our microsite, I have a chart listing for you all of the rule packages that are going to be coming out so you can keep this all straight. Now, in a moment, oh, yes, sir.
Are business methods considered part of your contested case proceedings?
Yes, yes. I group basically the 4 proceedings that the board will handle: post-grant review, inter partes review, the transitional method for program for business methods, and derivation to be, I call them in the aggregate contested cases. The reason I'm using that terminology, I've heard loosely people refer to it as the post-grant proceedings. Well, we have a proceeding called post-grant review, so I don't want people to be confused as to, am I talking about the specific proceeding, or am I talking about the 4 proceedings in the aggregate? So I've just chosen the contested case vernacular so that we can keep them all straight. Okay, now we're working very hard on our Group 2 provisions right now. Momentarily, I'm going to talk to you about our timeline and how quickly you're going to need to give us your feedback if you have thoughts on how we should structure the various rulemakings for these provisions. Before we get there, though, the office, I said earlier, we're making rules. We're running some studies, and I'm going to talk about momentarily the programs. So on this slide, I list for you all of the studies that the Patent Office is congressionally mandated to run and report on to Congress. There's a method to my madness to the color of the font. The black font represents provisions that are studies that we must have reported to Congress within the first year of enactment. And here's the due dates, 4 months and 9 months. And then the blue font represents those studies that we will report on sometime thereafter, 2, 3, 4 years. So I want to segregate out for you the first 2 studies on that chart, the International Patent Protection Study and the Prior User Rights Study. Both of those have due dates 4 months from enactment. So that's placing us mid-January. So right now, the protocol we're going to follow for all of our studies is we'll issue a Federal Register notice announcing to the public the scope of the study and soliciting you to give us written comments about the subject matter we're studying. We also are scheduling public hearings for this study where you can come and give us testimony about our topics for study. So for the International Patent Protection Study, we're being asked to look at how the Patent Office or another governmental agency can assist small businesses in securing patent protection in foreign countries. Maybe we can subsidize their patent filings. Maybe we can create some sort of a revolving loan where when the business, if they ever become successful, can repay the costs that we loan to them for their various filing fees. This study we're conducting in consultation with the Small Business Administration and the Department of Commerce. Our written comment period is open. We published our notice in the Federal Register on October 7th, so we need to receive your comments by November 8th. And then we're having 2 public hearings, both of which are in the next 2 weeks. Our first one is next Thursday, October 27th, at the PTO from 1 to 4 o'clock in the afternoon. And then following week, November 1st, Tuesday, out at the University of Southern California Gould School of Law from 9 to noon. We really encourage you to come to these hearings or give us written testimony because the subject matter of these studies are not areas where the Patent Office has a tremendous amount of expertise. So we need you to help us in completing these studies. The prior user rights study asks the Patent Office to investigate the scope of prior user rights in other industrialized countries, members of the European Union, Japan, Australia, and Canada. It also asks, another topic is for us to investigate the impact of prior user rights on innovation, venture capital. We are conducting this study in collaboration with the Attorney General, the U.S. Trade Representative, and the Secretary of State. We, in a Federal Register notice, also released details of the study on October 7th, so comments are due November 7th, and we have a public hearing scheduled for this Tuesday, October 25th, from 8:30 to 11:30 at the Patent Office. So I encourage you, for both hearings, consider written comments, consider coming and testifying, and to the extent you have interest, both of the public hearings are going to be available for you to watch in real time on our microsite, so you can see what's going on at the hearings. Now here, I won't talk anything about these studies, but these are the two studies where the PTO is a consultant. We're not leading the study. The organizations I list on the slide are leading the study, but we've offered details to both of those organizations, a Patent Office employee, to come over and help the folks prepare those study reports. Now, we've got rulemakings, we've got studies. We also have some certain programs that we have to prepare and get running. Again, the font color, black represents programs we have to have running within the first year, blue thereafter. The first program I'll talk about is the Pro Bono Program. It went into effect on the date of enactment. And we have a specialized program set up in Minnesota that connects under-resourced independent inventors and small businesses with patent attorneys. The program runs through a clearinghouse. The individual inventors and the small businesses work with the clearinghouse. They pay a $1,000 fee. It's an administrative fee for administrative costs. And the clearinghouse, which is a nonprofit organization that already does a lot of pro bono work, will connect the independent inventor or small business with a patent attorney. Once that connection is established, there are no fees, attorney fees, that the inventor or the small business will have to pay. It's true pro bono in that sense. We are looking to expand this program. So a pro bono task force has been formed, and the first meeting was yesterday. We'd like to take the program to other cities across the country. So if any of you have an interest in the pro bono program, participating in it, or if you know of independent inventors, small businesses that would benefit from it, I'm happy to put you in touch with the folks who are running that program. Just let me know. I won't go over any. I don't want to run too long, so I won't cover any of the other programs. If you have questions, please see me after or email me. This is the timeline, so that at any point you can receive a snapshot of what exactly the Patent Office is doing to implement the America Invents Act. So you want to know, you can look across the months. Let me tell you about the colors. The purple color at the top reflects the Group 2 rulemakings that are for the most part already implemented, with the exception of the one electronic filing incentive. The blue across the middle, those reflect the timeline that we're operating under for our Group 2 rulemakings. I'm going to come back and go through it in detail. The orange boxes are the studies, and the red boxes at the bottom reflect the programs. So now let's go back to the timeline. Well, within the first 3 months, the Patent Office is preparing our proposed rules. We're sitting down and discussing the architecture of the rules and what the rules themselves should look like. Now is a very, very crucial time for us, because right around the end of the second month, although I don't show it specifically called out, that's when the rulemaking needs to be in a form that we will start an internal clearance process. Around November 15th. Right around November 15th, we start internal within PTO clearance. It'll go to the business units, the law division, and the undersecretary's office. About a little over 3 months, we will release our rule package, the proposal, to the Office of Management and Budget, OMB. They have agreed to a 30-day clearance window. This is going to be very complicated for them because OMB releases the package to all of the other government agencies for their review that are affected, that potentially could be affected by the rule. Department of the Army, Department of the Navy, NIH. So they have a tough job to do within this 30-day time window. Assuming we are able to meet that, 4.5 months, we will come out for all of you to see our notices of proposed rulemaking. So in order to, you see, we're very tight right now. We need your feedback right now, ideally by November 6th. That gives us about a week or so to build it in, consider it, and put it into the package we send out for internal as well as OMB clearance. So if you have thoughts, I encourage you. I'm going to show you in a few slides. It's very easy for you to submit your comments. We want to hear what you have to say. Again, we see this as a collaboration. This should be completely transparent to you. You can also see the comments that are posted from your colleagues, so there can be a dialogue about this within the community. Once we publish it at 4.5 months, then starts a 60-day public comment period. That's our formal comment period. Formal in the sense it's following under the terms of the Administrative Procedures Act. Once we hear from you, we're going to have comments coming in on a rolling basis. We understand that. We also plan on doing some road shows across the country to talk to you during that 60 days, probably, like a month out into it. We want to go from East Coast to West Coast and hold some public roundtables where we can talk to you about our proposals and hear what your thoughts are in response. Then we'll go back into, starting around month 7, an internal deliberation process where we'll spend 60 days preparing our final rules. We're considering your comments along the way, but we're going to heavy-duty consider them in those 60 days because we'll be writing responses to them. Then we'll start the internal clearance process, which is about a month. The OMB clearance process, again, another month. And then about 10.5 months, we will release for all of you our final rules. The final rules will have a delayed effective date right now in my timeline of 53 days. Now, under the terms of the Administrative Procedures Act, we are required to have a 30-day delayed effective date. So that gives us 23 days of buffer to be absorbed along this timeline. And we have to look up here. We have some holidays coming in right around this period of time. We're asking for a lot of Herculean tasks here from OMB 2 times in the process. So I think by walking you through, and I know it might not have been the most scintillating discussion to hear the timeline, I do it so that you can understand there is very little room for do-over in here. And if you have feedback, we need the feedback as early as you can give it to us. Certainly now, and definitely in the formal notice and comment period so that we can build it in. It would be our ideal to release our proposed rules as a straw man for what you've already considered and what we know what you want and we've built it in then. It would be much more difficult for us to hear from you with major proposals and changes during this 60-day window because we don't have a lot of room. Now, you might be wondering, we've engaged our union in the process as well. Our union is sitting both of our unions, NTEU as well as POPA, are sitting with us and working together to help us develop these rule package. Union representatives are working with the policymakers across the process because we too know that if there's labor relations issues, we have to sort them out early in the process and not late in the process because of the statutory deadlines for a 12-month effective date. Now here is our microsite, and then I'll be wrapping up. This is the place where you've heard about to do one-stop shopping for all of our implementation activities. Every Federal Register notice, every memo to the examiners, all of our internal guidance documents are all going to be available on our microsite. I update the microsite every Friday. There's a subscription center here. I can't see the button, but there's a subscription center. If you register at the subscription center, you're going to receive an update every Monday telling you what I've updated. Now, I'm not telling you if I fix a typo, but a major update onto the website. You'll be notified so you know what's happening. There's also a box on this website for comments. So you click the comments box, this screen appears. Then you can select what category you want to make a comment to the agency. It'll open your email browser with the subject line already populated to say, oh, it's about microentity. It's about citation of prior art in a patent file. And then you can give us your comment. Yes, sir.
These are the comments for the rulemaking?
These are the comments that you'll be submitting preliminarily now for our proposed rulemakings.
36, 40, 2 or 3 weeks.
Yes, sir. Yes. And all of these comments are posted on the microsite so you can see. Now, here's the deal. Due to our automation constraints, the comments are posted, but they're not searchable. So that's why we're asking people in the subject line to identify the provision that you're discussing in the comment. What happens is we receive the comments, we have to PDF them, post them, they can't be searched. So if you do us the favor of indicating the topic so that we know where to direct it, and you all, if you want to look at the comments, can easily find what you're interested in. The way I'm handling comments is I have a database, I track when your comments come in, and I distribute your comments to the respective working groups who are preparing the proposed rules in that area. So that you are getting considered in real time. We're not holding them to the end, we're regularly distributing them.
So if we have a comment post-grant review, we put that in the subject line?
Yes, sir. Yes. To date, we've gotten 68 comments. This is the breakdown of organizations that have submitted comments. So we encourage you to bump up those numbers and help us out. Also, a big part I've talked about today is the transparency of our rulemaking process, how we want to engage with you and keep you informed throughout as to what's happening. So far we've done 28 speaking engagements across the country. You can see the geographic distribution of where all we've been. You can see the types of audiences that we're reaching. 82% of all of our speaking engagements have been in-person speaking engagements. We want to hear from you, so this is where we've been. We're going to continue. We're going to be in your neighborhood very soon. If you have an organization that wants us to come and talk, please let me know. We'll try to set something up for you.